see. Yes, Reiko.
That's very good. I'm sorry, I've been really busy. Who's going first?
I think we had
Judge
asked Judge
Forbes?
Forbes
Okay,
if she's okay to go first,
okay.
and then we'll see if there's any questions from the gallery. Um, Judge Forbes, do you want people to interrupt you with questions, or would you prefer them in the chat, or wait till the end?
I'm fine if they want to interrupt me.
Okay.
I just want to make sure everybody is seeing my slideshow because I get a weird different view of it.
I can see
Yeah,
it.
I can see
Okay,
it as well.
good.
Okay, great.
Okay,
So without further ado, please go for it.
okay. So hopefully this is going to work the way it normally does. Let's see. Okay, there we are. So I understand I'm speaking to court facilitators. So all of you are folks who already work regularly with unrepresented folks. So just to start with just a little background, I'm chairing a group called the Unrepresented Litigant Work Group. It was a work group put together by the Superior Court Judges Association. We have a number of stakeholders who come and participate in our work group meetings. And the goal of this work group is to try to figure out ways that the Washington state judicial system could work better for people who do not have the benefit of an attorney. There are a bunch of subgroups for that work group, one of which is Judicial Education Work Group, which is also focused on staff education, which would include court facilitators, court clerks, superior court staff, district court staff, and other similarly situated employees. So part of that is trying to figure out the best way to communicate how people can better help people who are not represented by lawyers to help them navigate this very complex system that was built for lawyers. Over the course of hundreds of years, we've implemented a lot of rules and regulations that were never really intended for people who are not lawyers to navigate. So that's sort of the background, and I'm happy to answer more questions about that, but I don't want to take up too much time with that because I want to focus on some of the efforts that we've been making, particularly work we've done on the Code of Judicial Conduct. But what's important to note is that this is a reality that we can't escape. There's only going to be more and more who will be participating in our justice system, and they do not have the ability to learn to be lawyers for their one case or two cases that they may have. And so we really need to work towards meeting them instead of expecting them to meet us in terms of the expectations that we have. Because I think our main purpose as a justice system is to try to actually assess cases and deal with cases on the substance and the merits of the case, and not barring cases from being heard merely because of a procedural difficulty. So I won't go into much more on the statistics. I think I'm preaching to the choir for sure here. You all are the ones who deal with these folks on a daily basis, so you know they exist. So I'm going to try to explain this a little bit. We do have Ms. Callner here from the Judicial Conduct Commission, or Commission on Judicial Conduct. I always mess up how to say that properly. And she's going to get into this in more detail. But the Washington State Code of Judicial Conduct consists of 4 different canons that each has overarching principles that guide the judicial ethics of judges and their staff, because staff is subject to the same rules, and judges, like lawyers, are responsible for ensuring that their staff complies with the ethics rules. Under each of the canon, there are a series of rules that sort of break down the principles into just kind of specific points on the rules. Under each of the rules, there are a number of comments that have been drafted that serve the function of providing guidance to judges and to staff to understand the application of the rules. They sometimes provide examples of things that are helpful to really understanding the meaning of the rule. And sometimes they identify aspirational goals for judges that help them implement the purposes of the canons and to follow the rules as they are presented. It says proposed canon amendments. I didn't change this slide. This is a slide from a training I did in April of last year of 2022. The Superior Court Judges Association and the Unrepresented Litigant Work Group proposed a number of amendments to the comments to the canons or to the rules, and they've actually been adopted. So these are no longer proposed. These are actual comments. And so there's a rule 2.2, that requires a judge to uphold and apply the law and their duties fairly and impartially. And this is oftentimes the rule that is the stumbling block for judges and I think staff in terms of trying to figure out how to navigate the system, how to provide assistance to an unrepresented person without violating the duty to be fair and impartial. And impartiality is where folks are like, I can't give legal advice. And that's something we say very regularly to folks who are not represented. So there was a clarification essentially put in or proposed that was adopted. That's comment number 4. That essentially says that making a reasonable accommodation to a person who is not represented by an attorney, which would give them an opportunity to have their matter heard fairly, is not a violation of the duty to be impartial. It talks a little bit about you have the duty to remain impartial and uphold. Doesn't mean that you can't make reasonable accommodations to ensure that they have a right to be heard, so long as those accommodations don't give them an unfair advantage. And of course, it doesn't require certain activity, but it certainly says it's not prohibited. The next part of the amendments that we proposed was to the Rule 2.6, which is the rule that requires judges to ensure access to justice. And so the comment that was added to that particular rule, Rule 2.6, helps explain what it means to help provide access to justice, or to provide access to justice to folks who are unrepresented. And so what it does is that it encourages judges. It's somewhat aspirational. It says that judges should endeavor to ensure that unrepresented litigants have a fair opportunity to participate in the proceedings. To do that, that means there might be some accommodations that you would make to an unrepresented individual that is different than you might do if the person was represented by a lawyer. And the comment to the rule goes on to give a number of examples, and I'm going to go through them, but if you want to copy this rule, I can absolutely pull it up for you. It is on the Washington State Court's website where all the rules are at, and I can certainly help you if you need any assistance getting to that. But here's some examples of things that judges can do, the court staff could do, that would not be a violation of the Rule 2.6 or 2.2. You can help by providing a list of resources to unrepresented individuals. For example, providing information about civil legal aid locations, places, websites that they can go to try to find forms or tips on how to navigate the system. Trying to make sure that folks who don't speak English have all the necessary interpreter service they might need to either review forms or to have the ability to communicate about their cases. It's also, I think, really helpful to inform unrepresented individuals about how proceedings work and what is involved in a particular hearing, what kind of process is going to be used, how evidence might be or might not be accepted. For example, informing individuals that I do this quite regularly, that I'm not going to look at their cell phone. I'm not going to look at the text messages on their phone or the pictures on their phone, that if they want me to do that, they're going to have to print something up and provide it to the court. And we oftentimes allow them to email them, and we'll print them up if it's appropriate to do so. But to try to help them understand why it is you can't do what you're doing. So I usually explain why. I said, I can't keep your phone and I have to keep a copy of anything that I consider. Using technology to help folks to appear in court or to present their case, such as using Zoom. We've done a lot better with this. This rule was actually drafted before the pandemic, or the proposed drafted before the pandemic. So this was sort of apropos of the future that we do a lot more of already. But it does help them to present exhibits, for example, and I oftentimes use it in settlement conferences with unrepresented individuals to sort of show them different websites that have resources for them, such as the Forbes website for the Washington State courts. It's also helpful sometimes to ask the questions that you need to ask. And so for a judicial officer in a hearing, when I have a decision, for example, on child support, and I'm not getting the information I need to make that decision, I will oftentimes need to ask some questions. And it's important for the judicial officer to not ask questions that appear to have a bias to them, but are rather just done to try to get more information or to clarify information. One of the issues, and I think you all experience this, is trying to explain things to folks who aren't lawyers in non-legal terms. We easily go to the words that we use, like note for motion. We know what that is, but for an unrepresented person, that's just nonsense. Those words don't make any sense to a person who's not a lawyer. So trying to use terms that make sense to them. So you're going to use a note for motion. What that means is you're going to fill out this form and it sets it for a hearing, and using words like that to help explain the legal process in non-legal jargon. As a judicial officer, I try to sort of lay the groundwork. For example, in a trial with unrepresented individuals, I'll talk about what I understand the case to be about. I'll tell them I haven't read their file, but that I've looked through the file to see sort of what's the posture of the case. Am I dealing, for example, with a first parenting plan, or am I dealing with a case where this is a relocation or a modification? Different standards apply. And then, you know, kind of just being very transparent about the process, like telling them what you may do during the course of the case. I have done this, the next one, I've done this before. It's sometimes very useful, not always, to take one issue at a time with litigants and sort of figure out where their conflict is, where their conflict isn't, and resolving their case, focusing on those points of conflict and sort of having each one explain their position one at a time and going back and forth. And then I think it's really helpful to let people ask questions to clarify, make sure they understand what you're doing or what the process is, and being open-minded to that. The next option a judicial officer can consider is using or allowing narrative testimony. This is a tough one for lawyers to accept, which is to allow an unrepresented individual to get on the witness stand and just speak their story and tell their position on things, because it doesn't give them an opportunity to object to something that might be improper. But under certain circumstances, this is appropriate to do. And I think most judges can separate when something's improper. It's not in front of a jury usually. If it is in front of a jury, this might be a little harder to do, but in the absence of a jury, most judicial officers can separate testimony that's proper from the improper and allow an objection after the fact and sort of disregard it on their own. The next one, this is also hard for lawyers to accept, is allowing parties to adopt written statements as part of their testimony. We do have the new process for the simplified trials. I can't remember, I forgot the wording for it, but the option for folks to essentially present declarations and statements of witnesses, and everything they present is admitted, and the parties have to agree to that process. But that's something that judges under certain circumstances might be able to do in the outside of that identified process that we have under our court rules. You have to be careful, of course, to always make sure everybody has an opportunity for full cross-examination, but to not necessarily overly strictly apply the rules. I've definitely had cases where on number 13, which is sometimes asking the questions that are needed in order to create the foundation. Sometimes there's something that's being presented, but you don't necessarily have all the information you need to know as to whether or not it's something that's reliable. And if it's a neutral enough question, the judge might need to ask that question to clarify, because an attorney objects as to foundation and say it's a photograph, and an attorney objects as to foundation, an unrepresented individual will have no idea what that means. And so I might say, well, who took the picture? When did they take the picture? Can you give me a little more information about the source of that photograph? And it's really about whether or not I should look at it in the first place, not necessarily about making sure or having a roadblock for this individual to present the picture that they want to give to the court. And so those are neutral enough questions that you're not showing any particular bias by asking those questions. This is one that I do over and over again. I'll be honest, it's really hard on represented litigants. Number 14, still don't get this, but I do try to emphasize it, that once the folks rest, they can't present new evidence, and so they're limited in their closing arguments to the evidence that's only been presented. And I think it's something you have to emphasize over and over again, because folks will oftentimes try to testify in their closing arguments, which they can't be permitted to do. But if you don't tell them that ahead of time, they don't know that, they don't realize that. So it's really important that you inform them before they finish that they really have to be done, and that it really means something to be done. rather than to have them go into closing arguments and then start talking about all these things that rebut what the other side just said that they didn't bring up in their testimony. I've had that happen, and the frustration that they felt was very apparent. So I try very hard to make sure they understand that before they officially and actually close. The next part is really about talking about going through a decision. It's important to let folks know that they don't need to interrupt you during your decision. If they have questions, that they're going to be given an opportunity to ask questions once the ruling is done. I'll be honest, I'm not always good about remembering to tell folks that. And then when they interrupt me, I'm usually is the point where I'm like, okay, well, I appreciate you have a question. Let's going to wait till the end. If you cannot interrupt me, it's helpful so I can finish my part. And then if you just want to write down your questions.
Judge Ford, should
yes?
we be on the next slide?
Oh, did I forget to turn? I'm so sorry.
Okay.
Thank you. Thank you. I got carried away. I have it in front of me, so thank you. When you're issuing a decision, it's really important you try to explain why you didn't follow or do what an unrepresented individual asked you to do. If you can explain it to them and say, look, I understand what you're saying, but the law restricts me to this particular issue. And this comes up all the time for judges. I am oftentimes there on a motion for contempt by one side, and the other side wants me to find contempt against the other party, but they've never filed a motion. I say, I can only decide the issue in front of me, and that's this issue. If you want me to consider that, you need to file a motion, and, you know, kind of go through that step of explaining that to them. It's sometimes hard to issue oral decisions when you have a case where you need to just do a written decision. But it's, I think, always best practices when you have unrepresented individuals to present that decision, whether you've written it up or not, orally to the parties, so you can explain it to them and so that they have a chance to ask questions or to tell you why, you know, you've ordered that they exchange the child on Sundays at 3, and why that isn't something they can do. And if it wasn't something that was really fully discussed at trial, it might be appropriate for you to hear that after the decision. I've certainly had cases where they've left gaps in the process about how to do things. So I make my best guess, because I need to finish the parenting plan. I need to have it finalized, and I don't expect them to write it up. So I'm going to just write it up myself with my provisions, but they haven't told me how every nuance works. And so it's sometimes it's very important, particularly in those cases, that you go over the provisions to make sure if you actually guessed wrong, that you can get it straightened out at that time instead of expecting them to do the impossible. Number 18 is kind of similar to some of the things we've already talked about, which is explaining the decision using lay terms to do it and acknowledging, you know, you've heard both sides, you've considered both sides, and here's why you made the decision that you made. Then it's important to make sure they understand. So if there are any concerns with that, make sure you clarify with them what it is they're expected to do, and telling them their next steps when that's appropriate. If there's things, for example, you expect them to get into treatment, explain to them what that means in terms of their next steps. And then it's always good to follow up an oral decision with a written decision. I know a lot of judges will not fill out final paperwork for unrepresented individuals. I will try, when possible, if there's a lawyer involved, to use them to do it. But I also have found that they don't always put it in my best words. So if I have an unrepresented litigant in a case, and oftentimes, really frankly, if I have lawyers in the case, I'll end up writing my own orders. But if I have 2 unrepresented litigants, I have found that it is almost like chasing your tail to try to get them to write it the way you would want to. So I oftentimes will write it for them. But if they are expected to do it, then it's important that you tell them sort of how they might go about it. So, for example, using folks like you, court facilitators, or other types of programs, or showing them where they can find the forms and the documents online, which I do oftentimes. I'll open up a screen share and I'll show them the Washington Court's website, and I'll go through to the link to the page for the family law cases, for example, and show them where the forms might be found. And then finally, it's really about showing respect, treating people with dignity. So thanking them when possible and appropriate for their participation and their involvement. And that's the last suggestion for folks under the comments. These are, again, recommendations, if you will. They're not mandatory things, but they are things that you can do as a judicial officer or where applicable as staff to try to ensure that folks who appear in the courtroom are in fact having a meaningful access to the courts or access to justice. I just throw this in here. This is really particularly almost my last slide here. And this is some of the things that we recommend to judicial officers to look at to try to figure out how to sort of navigate this difficult and complex issue. And so I just throw that up there for folks. My last slide is whether there are any questions, so I can leave that up for a few minutes if folks want to write any of that down or take a screenshot of it. But that's the quick, I try to go through that fast because it's a lot to cover, but I don't want to take up too much of your time because you do have Ms. Callner present here to also talk to you. But if there are any questions, I'm happy to take those questions.
And just so everybody knows, Judge Forbes is going to be logging off here shortly. So if you have questions for her presentation, if we can please get those captured now.
And I'm happy to take any of your hard questions if you want. But I know sometimes it's hard with judges. So if you have any question you want to ask a judge on this topic, I'm happy to help with that.
Good morning, Judge Forbes.
Hi, Becky. How are you?
I'm good. Okay, so just to give you guys a heads up, she's around the corner and I clerked for her for quite some time. So she's absolutely one of my favorites, but I'm going to say this out loud because I'd love to hear your answer. Facilitators have different bosses throughout the state. Some of us work for the clerk's office. Some of us work for superior courts. Some of us work for pro bono organizations. And so where I get a little confused is when you're talking about court staff. But for instance, I am an employee of the clerk's office. Does any of that, I mean, we still have all the same ethics, but how does that affect us with some of this if we don't actually work for a superior court? Or does it?
Well, that might be a question that Ms. Callner can better answer. I don't know that the ethics rules that we're talking about apply to the clerk's staff per se, but the issue of navigating the concept of not giving legal advice and but also helping people access the courts, I think is the same whether you're on the clerk's office or on the court side of things. The ethics rules apply to like lawyer ethics rules. They apply to their staff as well. And so the lawyer can't have their staff do something they can't do themselves. And so they're responsible for ensuring that their staff complies with those rules, like not violating confidentiality and things like that. So to that end, I'm responsible for ensuring that my staff doesn't do something that's inappropriate. Now, there are definitely some rules that obviously don't apply to staff. Like my staff can go work on a board and volunteer and fundraise all they want. But for the most part, there are certain things that they have to be careful of doing that we have to ensure. And so I think it's more of an issue for the judge if they violate it, where it becomes an issue from there. But I guess, Ms. Callner, I'm making some assumptions as to how this works. That's my recollection, that there's a provision in the rule to that effect. But I don't think that those rules technically apply to the clerk's office.
Technically, no. The rule in question is Rule 212, supervisory duties, and these are the rules that pertain to judges and are enforceable against them. And Rule A under 212 says that a judge shall require court staff, court officials, and others subject to the judge's direction and control to act with fidelity in a diligent manner consistent with the judge's obligations under the code. Very like what Judge Forbes said about you can't direct somebody else to do something that you're prohibited to do if you're a judge. So that's one way of looking at it. But another way of looking at it is these rules are here to assure that justice is delivered. These are the basic core values of the justice system. So whether they're specifically enforceable against a judge when a courthouse facilitator were to act inconsistently with the rules is sort of a whole nother question. What you're trying to do is to deliver justice in a way that makes sense and is fair to the people who come before the court. And so, as well as enforceability aside, and who would be subject to enforcement of these rules is one thing, but the guidance that the rules are there to offer is what can you do to make sure that people receive the justice that they're due in court.
So I don't know if they answered your question, Becky. You're muted. There you go.
I think I was trying to make sure you understood how many different bosses facilitators have.
Sure. Yeah.
Because everybody's different.
Yeah.
Every single county is different.
And that's a really useful point.
And so there are counties that have staff facilitators that work for Superior Court and the clerk's office. I think it's Thurston, but I don't remember which counties do that. So I guess I just wanted to clarify and make sure you guys understood that part too, because I don't know how that affects it.
Yeah.
But you know me. Okay, she really does know me.
I do.
Putting it into simpler terms. And the example I will give is I sit here every single day explaining what the term pro se means to people. They do not know what that word is. They have never heard it. And we throw it around like it's just normal, and it's not. So explaining the legal jargon is huge.
Yeah, and our work group, the best terminology is unrepresented litigant. That's the terminology you'll see us use always. I don't use pro se very often. It's the old school way of putting it, or self-represented is also sort of a misnomer. It really doesn't accurately describe. They're unrepresented. They aren't self-representing because they don't know what they're doing. They're unrepresented litigants. So that's I think the best practice term. That's the term that's used nationwide for folks that this is the focus of their attention. So I agree with that. Okay, if there are no other questions, and again, I'm happy to take any if you want to. I can take it if you want me to, but I will depart so you guys can have a frank discussion without me, and I can have my lunch. I'm in a jury trial, so that will help me to go get my lunch. So, okay, with that,
Thank you, Judge
everybody.
Forbes. And if
Thank
anything
you.
else, pops up, I'll be sure to send it your way as well. So thank you so much for joining us.
Yeah, and I just want to say I appreciate everybody really caring about this subject. The work you guys do obviously is really focused on this. And so this is to me really important. It's near and dear to my heart. So thank you all for that work. I know it can be trying and and sometimes difficult. So thank you, everyone.
I guess I was waiting to be introduced or something, but I think it's my turn.
Thank you, Reiko. Yes, please go ahead and just join
Sure.
right in.
So I'm really, really glad, as is just to echo Judge Forbes, that you're addressing this and asking for presentations, and you should continue to do so as issues arise. I've had the pleasure of working with Judge Forbes and helping some of these comments become law that expand on how you can make the courtroom experience better for an unrepresented individual, because they're anxious, and whatever they're coming to court about is incredibly important to them, and they're on foreign ground. Sometimes the people who are making the decisions are literally using a foreign language, Latin most common. And you'll often hear coming from judges or from others the maxim that an unrepresented person is held to the same standard as a lawyer. And that's generally true in case law, but it is also kind of unrealistic and potentially kind of mean, because that person isn't an attorney and they don't know all the complex rules of court procedure, rules of evidence, etc. Yet this issue is incredibly important to them, whatever they're coming before the court for. And so what is really unfortunate, and what these comments to the rules are supposed to counteract, is the possibility that a judge or court commissioner would adopt a sort of a game-like approach. If you didn't say the magic words to invoke jurisdiction, you didn't lay the foundation properly, then you're out. Whereas the point of the entire exercise of the justice system is the fair adjudication of disputes. And so in order to get there, you need the facts before you. You need to have the merits of the issue come into court so that unrepresented litigants aren't just bounced out on a technical problem. Yet those technical issues are there also for good reasons. So judicial officers have to kind of navigate between those lines, adhering to the law, but also getting to the merits of a process. And the whole point of adopting those comments to the rules that Judge Forbes went over is to let judicial officers know in black and white related to the code that, and reassure them that you can take these measures to assure that there's fair access to justice without running afoul of the code. I'm going to run through a slideshow really fast. Hopefully this will work, and just explain to you kind of the basics about the commission. I understand we have till 1. Blue circles.
I think we just lost. Oh, there we go. It looks like Reiko's back. Did we lose you there for a moment? You're muted still, Reiko.
Okay, am I there? Sorry about that.
There we
All right, I am so hoping that I'll be able to slideshow. And if not, I will just talk and do a little interpretive dance. All right, I was just complaining about the 21st century. Come here. Okay, are people able to see the slides?
You're good, Reiko. Thank you.
That's a yes. Okay, great. All right, so I'm going to tell you real quick about the Commission on Judicial Conduct. So all of the 50 states and the District of Columbia have some form of Judicial Conduct Commission. And while they're formatted differently and the rules are a little bit different, even the codes in the individual states are slightly different. In the main, they do the same thing. They're responsible to assure the integrity of the judicial branch by enforcing a set of ethics rules on judicial officers. And they're also supposed to safeguard judicial independence. Now, the code isn't just a bunch of enforceable rules that make judges scared. There are, in fact, the articulation of the core values of the justice system. And it is helpful to think about the rules as how do they relate to the basic requirements of what it takes to have a justice system. I've trained judges around the country. I've trained people actually around the world in over 30 different countries, and also people who aren't attorneys or judges at all. And when I ask folks in whatever setting and whatever location, what are the fundamental building blocks of a just system of justice, the answers are the same universally, and they are historically throughout time. Think about what does it take to have a fair justice system. You're basically going to hear the same thing from any human. That system and that judicial officer has to be trustworthy, neutral. They have to be fair. They have to give people in similar situations equal treatment. Their rulings must be consistent and not favor one class of people over another. They need to afford due process, notice, and the ability to be heard. They need to have transparency. Their decisions need to make sense and comply with the law in a way that is trackable. Justice has to be accessible, and that judicial officer has to be competent. So if you look at the Code of Judicial Conduct, which is what we all enforce, and it's based on a model code, so in each state they're substantially similar, there are 4 overarching canons that give general principles of what is required of a judge in the code and what the basic core values of the code are. First of all, a judge has to uphold and promote independence, integrity, and impartiality in the judiciary. They have to avoid impropriety and even the appearance of impropriety, because their duty is for the public to have trust and confidence in their rulings. If they make a fine, just decision, but they do so in a way that looks fishy and sketchy, then they've violated the appearance of impropriety. So they have a duty to maintain both those standards. Canon 2 covers what judges have to do as they're performing the specific duties of their office, presiding over cases, making their administrative decisions, and they have to do all those things impartially, competently, and diligently. A judge is a judge 24/7, so Canon 3 covers what they have to do in their off time when they're not specifically fulfilling their judicial duties. A judge, for example, who in their private time commits, I don't know, a criminal offense, is still bound by the code, and they have to conduct their personal and extrajudicial activities to minimize the risk of conflict with of their office. Finally, in Washington state, we make judges run for office on the whole in order to become judges. And so Canon 4 covers political activities and campaign activities. And again, those rules require that the judge has to be consistent with the independence, integrity, or impartiality of their office. Now, under those 4 overarching canons are rules, and the rules are what we enforce. For example, Rule 1.3 says that a judge, so Canon 1 is that overarching, maintain the, uphold and promote the independence, integrity, and impartiality of the judiciary, avoid impropriety and the appearance of impropriety. Rule 1.3, one of the enforceable rules under that general canon is don't abuse the prestige of your office to advance your personal or economic interests or let others do so. Don't get a best seat in a restaurant because you're Judge so-and-so and it says so on your reservation. And then under each of the rules, there are comments, and the comments don't expand on or detract from or change the rules, but they give you proper guidance on the purpose, meaning, and application of the rules and identify aspirational goals for judges. That's what Judge Forbes was talking about. The comments to rules 2.2 and 2.6 is what got explained. So an example of a comment in action is that it's improper for a judge to use or attempt to use their position to gain personal advantage. So it'd be improper for a judge when they're stopped by a police officer for possibly speeding to say, "Hi, I'm Judge so-and-so, officer. Can you tell me why you stopped me?" That part doesn't matter. I'm going to move on. Just to let you know, our commission also takes up incapacity proceedings. So if there's a judge who suffers from an incapacity that's permanent or likely to become permanent and seriously interferes with their ability to perform judicial duties, the commission can investigate that and, if necessary, lead that judge to retirement. Whereas otherwise you might have an incapacitated judge staying on the bench. There are members of the commission are defined by the constitutional provision creating the commission. We've got judges from the Court of Appeals, Superior and District Courts, and a majority of non-attorneys who are appointed by the governor. And the idea of that is that the majority of voting members of the commission represent the public that is either required to or has to resort to the courts to resolve their issues, not people who work in the court system. Our complaints, we receive complaints from any source whatsoever. We keep our complainants confidential. We don't provide to the judge the original complaint. And the reason for that is the Constitution requires the commission to conduct an independent investigation of whatever the allegation is. So the complainant said whatever, and we investigate whatever. If we proceed against a judge or end up dismissing the case, it's not based literally on what the complainant said, but the results of and the commission's application of the code to that investigation. So when we do enforce or contact a judge to ask for a response, it's not based on what the complainant originally said. They just pointed us in that direction. It's based on the commission's investigation and analysis. That's another reason that we don't provide the original complaint to the judge. Now, I'm going to talk about confidentiality. It's enshrined in the Constitution. It's really robust. It's one of the only confidential provisions in law that is enshrined in the state constitution. And so it requires that we keep the fact that there is a complaint or investigation pending, or one that was considered by the commission and then dismissed, confidential. We must keep that confidential entirely. That's for two main reasons. One is judges and judicial officers, like court commissioners, can be pretty influential and powerful people. So the confidentiality is there to protect complainants and witnesses from possible repercussions for talking to the commission or providing us information. The flip side of the confidentiality policy is that, as is true in all 50 states, the vast majority of complaints against judicial officers are dismissed after investigation. And the reason for that is that a typical complaint comes from a person who went to court on something real important to them, really sure that they should win. They lost, and they file a complaint because they've concluded that that judge either made up their mind in advance, or was in the pocket of the other side, or is incompetent, or some kind of combination of those three. But really, at heart, they just really, really disagree with the judge's discretionary decision. That's not a code violation. So the vast majority of complaints do get dismissed. So the confidentiality also protects judges' reputations from unsubstantiated complaints being unduly publicized, and also prevent our process from being abused as a means to harass judges. Because even if it were an unsubstantiated complaint, if a judge knows there's a complaint pending against him or her, that generally is going to cause an incredible amount of anxiety, and also may interfere with their ability to neutrally preside over the case. So basically, all judicial officers in this state have been complained against probably more than once. The commission completed their investigation, and the matter was dismissed without the judge ever being apprised of it. This slide that I've had sitting up here is sort of a flow chart of what the process is of complaints. Above the line that says confidential is the vast majority of cases. In a small number of cases, there is a finding of probable cause and a statement of charges filed publicly, and thereafter the proceedings are public. If a judge is found in violation of the code, they can be sanctioned. And I'll describe to you the options for sanctions in a moment. These are just most commonly received complaints. Like I said, normally people disagree with the ruling that the judge made, or they'll say there's a bunch of things wrong with that judge because they didn't like the way they ruled. We do get complaints about what we call injudicious temperament. Judges have to treat people that they interact with a certain baseline of courtesy, dignity, and respect. And if they fall beneath that, then they can and are sanctioned by the commission. And that's just a graphic illustration of sort of the ratio of complaints that are dismissed and those that are sustained. The sanctions available to the commission range from an admonition, which is a written warning of an advisory nature, and the intermediate sanction is a reprimand, a finding that they violated the code and they have to do some remedial action to improve. The highest sanction available to the commission is a censure that finds that they violated the code in significant fashion that undermines public trust and confidence in the judiciary. A censure could be accompanied by recommendation from the commission that the Supreme Court suspend that judge from office for a period of time or remove them from office. And only the Supreme Court can suspend or remove a judge, and they can only do so through a recommendation by the commission. A judge can stipulate and agree that they violated the code and accept a sanction, and there have been some that have stipulated or agreed to be censured and also to resign from office, and the Supreme Court doesn't have to intervene if a judge is going to resign. There's a lot more detail, but what I'd like to do is to get to your question, but I want to give you a couple more points. It is well established in case law that if, despite our rules about confidentiality, a complainant or somehow somebody tells a judge they had a complaint filed against them, that knowledge on the part of the judge does not require the judge to recuse from the case. Otherwise, it'd be really easy to just, I don't like the way the judge is ruling. I'm going to let him know I filed a complaint against him, and then I got rid of him. It doesn't work that way. It's very specific. So judges generally don't know that a complaint exists, or if they do find out, they don't know who filed it. And retaliation against someone for filing a complaint or cooperating with the commission is considered a separate and serious offense under the code. There is a statute that provides immunity from lawsuits for defamation, absolute immunity for information shared with the commission. Doesn't offer immunity for information shared with the media or others, but it does offer immunity from defamation torts for information provided to the commission. And I could give you some examples, but I'm going to stop sharing right now because I believe that I'd really like to save some time for any of your questions. And anything said to me, I will hold in confidence, but I do see that we're recording and I don't know what's going to happen to
Yes.
that. And I don't know how your public records response would consider that.
Yes, I will go ahead and stop recording then, so we can open that up for unrecorded and